The first decision that we're going to look at is the decision whether or not to assess. The requirement for the local authority to make a decision is going to be triggered either by a request for assessment, and that request is only going to come from the following people: the child's parent, a young person, or someone acting on behalf of a school or post-16 institution. There is another way the local authority might have to make a decision, and that is if they become responsible. This will be, for example, where a child or young person has been brought to the local authority's attention by a health or social care professional. The key thing to remember is that the Act, Section 36, doesn't set out any particular way that that written request must be received, so any written request, however brief, may trigger the assessment process. Within 6 weeks, the local authority will have to make that decision whether or not to assess. And Section 36(8) sets out the legal test. It says that a local authority must assess where the child or young person has or may have special educational needs, and it may be necessary for special educational provision to be made for the child or young person in accordance with an EHC plan. There's an additional consideration in Section 36(10) where the young person is over 18, and that is, does that young person need additional time to complete their education? A key thing to remember here is that unlike under the Education Act 1996, which dealt with probability, here we're looking at possibility, so the test is slightly wider than it used to be. The local authority is responsible for this decision, but remember, other parties have duties to cooperate with them. And a key thing, which is upheld in all of the case law, is that applying a stricter test than this statutory test in Section 36(8) won't be lawful. This is where local authority policies need to be considered in line with this test. The legal test in Section 36(8) has some definitions, and we're going to look at these in more detail now. The first one is special educational needs, and a child or young person has special educational needs if he or she has a learning difficulty or disability which calls for special educational provision to be made for him or her. Just remember, it's possible for a child or young person to be disabled, for example, but not to have SEN, and the other way round. The next definition is learning difficulty. The Act says that a child of compulsory school age or a young person will have a learning difficulty or disability if they have a significantly greater difficulty in learning than the majority of others of the same age, or they have a disability which prevents or hinders them from making use of facilities of a kind generally provided for others of the same age in mainstream schools or mainstream post-16 institutions. It's a slightly different consideration for children under compulsory school age because we look forward and they'll have a learning difficulty or disability if they were likely to be within that definition if they were of compulsory school age, or would be if no special educational provision was going to be made. There is no clear distinction between what is a learning difficulty and what is a disability, and there will be a great degree of overlap there. And the key thing to remember is that just because a child might be academically able does not necessarily mean that they don't have special educational needs or a learning difficulty or disability. The next definition is special educational provision, and this means educational or training provision that's additional to or different from that made generally for others of the same age in mainstream schools, mainstream nursery schools, post-16 institutions, or places where relevant early years education is provided. A more detailed definition of training is available in Section 15ZA of the Education Act 1996. This hasn't changed under the new regime, and it includes things like vocational training, part-time training, and apprenticeship training. An important section of the Act is Section 21(5), and this is the section which says that healthcare provision or social care provision which educates or trains a child or young person is to be treated as special educational provision. The leading piece of case law here, which we've referred to in the slide, is DC and DC against Hertfordshire, And in this one, the upper tribunal acknowledged that the question about whether or not some provision is educational is a vexed one. There is no bright line test to determine this, and if needs be, you'll have to go back to the definition of education as found in the dictionary, such as systemic instruction, schooling, or training. The decision not to assess will trigger a right of appeal to the first tier tribunal, and the deadline is 2 months from the date that the decision not to assess is issued, or a month from the mediation certificate, whichever is later. It's compulsory for parents of children or young people to consider mediation, but it's not compulsory for them to participate. Unlike other appeals, hearings on decisions not to assess will be held on the papers.